And if you don't file a motion or make an objection or raise an issue when it should be raised, you're waiving it and not preserving it for appeal. Hello, this is Lana Manitta with the Rawson Law Firm. I am back to talk to you today some more about federal criminal defense motions practice. Remember to like and comment on this video and subscribe to our channel. We try to present educational videos on a wide variety of topics related to criminal defense, both in the federal system as well as the state courts of South Florida. So without further ado, let me dive back into federal criminal motions practice. I've talked in some other videos about there being really very little limitation beyond a prohibition against frivolous motions placed on criminal defense attorneys. And so while there might be page limits or word limits to the length of a motion, there's not really a limitation on the number or subject matter of motions that can be filed in a criminal case, as long as they have a sound basis in law or fact, or both ideally. And if you don't file a motion or make an objection or raise an issue when it should be raised, you're waiving it and not preserving it for appeal. So it's really important. And if there is an issue, that counsel is getting it on the record at the appropriate time, and motions are an avenue for that. Now, we've also discussed before that a lot of the motions that are going to be filed in a criminal case arise out of the review of what's called discovery, or the evidence or supporting documents. And when I say documents, it could be video, audio, you know, PDFs, Excel spreadsheets, lab results, autopsy reports, photographs, what have you. Looking at that material often gives counsel ideas for suppression, exclusion, and other challenges to evidence. But what we're talking about today, in the fourth of a series of videos about motions challenging the indictment, are is challenges to the charging document itself, using what I call a top-down approach to determine what, if any, challenges can be made to the actual, to the charges as they have been set forth in the indictment. We've talked about subject matter jurisdiction. We've talked about personal jurisdiction, venue, severance, multiplicity, duplicity, and double jeopardy. All of these that we've talked about in past videos touch upon the information that's found in just the very first few lines of a federal indictment. The part of the indictment where it tells you what court your case is in, that it's in a federal court, and the names of the parties. Now we're moving into the body of the indictment, where the charges are laid out in narrative form. Now, all that's really required in most districts is what's called notice pleading, meaning all that's required of the government is that the defendant is put on notice of what he or she is charged with, and given a very, very general idea of the conduct that the government says comprises the commission of the offense, a general idea of the time frame, on or about, and somewhere in that district. Sometimes the indictment does not contain enough information for the defendant to know even the basic information about what it is they supposedly did wrong. And so in that instance, one of the early motions that a defense attorney can file is called a motion for a bill of particulars. That's asking the judge to order the government to state the charges and the conduct that they say comprises the offense conduct with more particularity or more detail, more information, so that counsel and the defendant, more importantly, know what is it that I'm defending. When did this take place, allegedly? Where did it allegedly take place? If it's a conspiracy that's alleged, who else is alleged to have been involved in this conspiracy? Now, the judge may or may not grant your motion for a bill of particulars, because, again, notice pleading is all that's required. But if counsel can argue effectively that the indictment simply does not provide enough information for a defendant, and his counsel. To even begin to be able to prepare a defense, it is possible to be successful in this motion and get more information. And then, if you do get a bill of particulars, the analysis that I've laid out of the indictment, that top down, starts all over again with the bill of particulars. Now, also within the body of the indictment, this is where the charges again are laid out in some detail or potentially no detail. There are a wealth of potential motions found in there. Some of them we've covered in other videos, and some others we're going to cover in some future videos. But for now, I ask that you like and comment on this video and subscribe to our channel. Thanks for watching.